get out of the way. Call this meeting of the regularly scheduled Natrona County Planning and Zoning Commission to order at 5:30 on the 8th day of September 2015. Thank you all for coming. I would remind you that in the back of the room there's a sign-in sheet, and we would ask you to sign in there, please. Please turn off your cell phones while this public hearing is being conducted. With that, we'll get on with this. Introduction of the commission. Our director is Jason Caderas. Our administrative secretary is Peggy Johnson. Our planner is Trish Chavez. Heather Malone is the acting county attorney. I'm hoping she's here tonight. Haven't seen her yet. Commission members on my far right is Mr. Jim Brown. Commission member on my left is Mr. Tom Davis. I'm Chairman Harold Wright. As you can see, we're missing a couple of members here, so we'll do the best we can with what we got going on. For your information, we are an advisory board of the Natrona County Commissioners. Our decisions are subject to approval, conditional approval, denial, or change by the county commissioners. All agenda items are automatically advertised and conducted under a public hearing by the Board of County Commissioners to be held on October 6th in this room. This is Commissioner Hal Hutchison coming in. For those of you wishing to speak to address the issues on the agenda tonight, I want to inform you that we are recording the minutes for accuracy, and when the chair recognizes your turn to speak, please stand, come to the podium, state your name and address clearly, please. An additional reminder, this is an official public hearing where everyone will get the opportunity to be heard. Those in favor of agenda item will speak first, followed by those in opposition. The applicant may get a brief rebuttal time after all testimony has been received if they so desire. This is not a forum to tolerate any public outcries or non-addressed speaking from the audience. Any out-of-order conduct will be immediately addressed, and if repeated, the person will be asked to leave this public hearing. This is an important one here. There is an appeal process that you can apply for must be in writing to the Board of County Commissioners within 8 days of this decision. Okay, with that, now we have 3 members from the last meeting here to talk about the minutes of the last meeting. Where do we stand?
Mr. Chairman, I move approval of the minutes of the Planning and Zoning Commission of August 11th, 2015.
I'll second that.
Okay, any further discussion? If not, all in favor?
Aye.
By saying aye, all opposed, same sign. Motion carries. Minutes of the last meeting are confirmed. Okay, with that, we'll get into our agenda tonight. First item is ZC 15-2, a request by Daniel McGlade for approval of a zone map amendment from the existing urban agriculture UA zoning district to the light industrial zoning district on a 9.73 acre parcel. With that, I'll ask for the staff report, please.
Mr. Chairman, Commissioners, we do have zone change 15-2, a request for zone map amendment by the applicant Daniel McGlade.
Oops.
It's working a little bit. Here it is. ZC 15-2. Subject property is Weston. Subject property is located roughly at the intersection of 0 and Robertson Road. Here we have our subject 9.8, just under 10 acre lots located at 0, right off of 0 west of 0 and Robertson Road. Surrounding zoning, you can see here we are urban agricultural and then light industrial being the gray. Here is our Google Map version of it. Again, Zero Road, Robertson Road, we're just west. Another point of interest that I've been able to use on this is the former Pepsi-Cola building there that was right at the corner of Zero and Robertson. The subject property is just west of that building. Here's a photograph at subject property looking south. Subject property looking northeast, looking to the southwest, standing at the northeast corner. Facing west, this is looking down Zero Road. This is the subject property looking east. This is the former Pepsi building that we've all been accustomed to. General standards, the applicant must demonstrate that at least one of the following criteria is met. 1, is it necessary to come into compliance with the development plan? 2, existing zoning was declared. 3, existing zoning of the land was based upon a mistake. 4, existing zoning failed to take into account constraints. 5, the land or its surrounding environs has changed or is changing to such a degree it is in the public interest to encourage redevelopment. This number 5 is the criteria that the applicant has elected to use as their criteria for justification of the zone change. And number 6, necessary in order to provide land for a community that was not anticipated at the time of the adoption of the development plan. Here's the reason the applicant has provided for criteria 5. Seeking the zone change to address changing environment on Zero Road. Applicant owns the property to the east of the subject property, which is zoned light industrial. All the lots to the north and east are zoned light industrial. Applicant has purchased the property either for resale or retail to a commercial buyer or tenant. The buyer or tenant would need the ability to perform light industrial activities similar to the surrounding businesses. Proposed finding of fact. Staff does not find the evidence provided meets the criteria number 5 for the following reasons. The light industrial properties in this area have existed for over 35 years. The surrounding LI zoning district is as follows. Westgate Park number 3 was zoned in 1980. Zero Industrial Park was zoned in 1977. O'Quinn was in 1978. And rangeland northeast and east in 1980. That rangeland is the balance of the light industrial that is further to the north and the east, outside those subdivisions. The zone change is not supported by the development plan. The development plan for this neighborhood is as follows. Land use projection is limited to residential and industrial infill areas. The land plan calls for agricultural with no new residential subdivisions and limit development. The goal applied to this neighborhood is to preserve agricultural lands.
Yep.
Changing the zone would, in fact, reduce the agricultural lands out there. Key issue, should Natrona County approve a zone change from urban agricultural to light industrial when none of the criteria has been met? Public comment. As of tonight's meeting, there have been 31 comments in opposition have been received. We've included those in the packets for you guys' review. There's also been some conversation from members of the public about deed restrictions and or covenances placed on this piece of property. Both of those are a civil matter that if they are violated, that's up to the property owners to remedy. That does not involve county involvement, but want to make you aware that that's out there. If you have specific questions about the deed restrictions and or covenances, the applicant's representative is here today, and so we need to ask him of those questions. Staff proposes a motion and vote by the Planning and Zoning Commission to recommend denial by the Board of County Commissioners of the proposed zone change from urban agricultural to light industrial zoning. Staff also recommends that the motion incorporate by reference all facts set forth herein. Tongue title of this evening, gentlemen. With that, I'd answer any questions.
Mr. Chairman? Yes. Jason, on the view facing east, that water, is that part of the irrigation system, or just happens to be after a wet day in Barrow Ditch?
No, that's
No,
right.
I believe that is a Casper Alcova irrigation canal.
Yeah.
Okay. And does that take a right turn along the east side of the property? Where does that go?
I believe it continues down Zero Road and actually goes underneath Robertson Road. Let me get to my aerial here, Commissioner. I believe that irrigation canal goes down here and goes underneath Robertson. I'm not certain on the logistics on how it gets back across this area, but I believe it crosses underneath Robertson Road. Heads eastward.
Thank you.
Tom? Anything?
No questions at this point.
Okay, I guess not. Jason, thank you. With that, we'll open the public hearing on this agenda item. Anyone wishing to speak in favor of this agenda item?
Mr. Chairman, Commission, I'm Mike Lansing, 125 West 2nd. I'm here on behalf of the applicant, Dan Glade, as he is out of the country at this time. I want to address the covenant issues. I found there were no questions unless there are of the deed restrictions, as it is a civil matter between those involved. If there is, I have it here and I can answer why we were aware of this and chose to move forward with this request. But if not, in meeting that criteria that this area is changed or changing, as it is pointed out, these areas of the industrial are 35 years old. All that land was not filled in at that time. It has been sold by various people. If you've driven through there over the last 35 years, you will notice a great number of activity, especially during the last most recent boom of oil and gas and other type of light industrial companies filling in that infrastructure. Most of that land is now is taken up. And if you really notice to the east, that is heavy, it's filled in with light industrial, and this boundars on both the north end and the east end. And as since 2000, when this was first put in, all that infrastructure to the north and east was not filled in. Therefore, as this fills in, we believe that there's a need for the change to allow that corner lot to kind of be incorporated into both the north and the east use for light industrial use. I noticed Commissioner Brown, you brought up the irrigation district, and obviously that ditch would remain there. There'd be no encumbrance of that use because there's an easement there and it could not be used, and that would have to be incorporated into any building plan for egress and ingress into that. Therefore, just the use of the purpose of the land, as was stated, Mr. McGlade he bought the Pepsi building, and then he also owns the land further off. If you probably noticed during the crane sale recently, that was Energy Transportation. That's also owned by Mr. McGlade. So he was buying and purchasing this land for further expansion into the light industrial area. I know that land was used, I think they were haying on it. If you're worried about converting that, we want to keep it, the purpose was to keep it as agriculture. It's not Mr. McGlade's purpose and intent to use that as agriculture, so even if this was denied, I don't think that's going to be in the use of it, and it'll probably go after one of the other uses underneath the conditional use permit that would be asked for. So, I know it's not one of the considerations, but it is a consideration of the commissioners. Obviously, if we move it from urban agriculture to light industrial, it will service as economic growth for the community, and it will also add, obviously, to the tax base in both jobs as well as in tax revenues. With that, I would be open for any questions.
Mr. Lassie, you said you knew what the covenants were on the property. Can you?
Yes, the warranty deed was done in 1972 in a transfer, and it covers this land, this land, this land, and this land. At one time, I believe it also incorporated all this, but through another subdivision that was removed, is my understanding. The covenants do not allow for a period of 25 years after that, and then successive periods unless somebody contests it by a majority vote. And it does say that its primary use should be for single-family residential purposes. Okay. But later on in the second part, it also talks about no commercial farming or livestock raising. As we're aware in Wyoming law, if this land was used for commercial farming at any time, or any of these other lots, or even this one, it was in existence, was used for commercial farming, then those covenants have been breached and most likely would be deemed abandoned. And that's what they would be seeking after if they got this zoning. This is step one. The second part would go after an abandonment of these covenants, because you can't pick and choose which of the restrictions and covenants that you want to go after. You have to follow them all the way through.
So I'm confused, if it's zoned for urban agriculture,
You
you
got
can
me.
farm it, is that not correct?
Well, it said by zoning, but not by covenants. Like you said, the covenants is a county issue. And this says no commercial farming. I'm just reading it, section 2. So the covenants go directly against what it was zoned. So it would take a civil matter not brought by the county. Because the county, when they zoned it, they don't always have to check all the covenants that are set for it.
Well, I would assume that county zoning laws would overcome the covenants.
You might have other people that disagree with that, but it would be an argument for me that if you're zoning it, you can't pick and choose the covenant. So if it's been zoned farming, it's been used for farming, then the covenant should just be washed away and be voided and abandoned. And that's what Wyoming law states.
Thank you.
Okay? Any other questions?
Mr. Lansing, did you point out the old energy transportation property that we referenced it?
The energy transportation property is this right here.
Okay, then on
And across the
the
street.
west side of
Right here.
Robertson, where are all the holdings of this?
So this is the Pepsi building.
Okay.
You want to know what those other are?
Well, you mentioned energy transportation, I didn't know the extent of
Oh, okay.
the other side of Robertson Road.
Yeah, it's not connected.
No, they're not connected. I mean, it's owned by the same owner, but it's not connected.
Sure.
Okay, thank you, Mr. Lansing.
Thank you, Commissioner.
Anyone else wishing to speak in favor of this agenda item? Anyone else wishing to speak in favor of this agenda item? Anyone here wishing to speak in opposition to this agenda item?
If you give me just a second, I gotta get everything prepared. I wish I had known you had this. I would have brought the actual presentation, but as such, I didn't bring copies. This is a copy of the covenant, and actually it's not a covenant, it's a deed restriction. I found out there is a very big difference. Covenant is just a gentleman's agreement.
Can we read that?
Huh?
Can we read it?
Absolutely.
The one that's in here, you can't really read.
It says a bunch.
If you could just keep it for reference in front of you. This one, hopefully it's a little bigger.
Thank you.
And also, the map. Well, good afternoon. I appreciate the opportunity to speak in front of you.
Name, please.
Melanie Peterson. I actually live, well, we're in the process of building a house on 695 6 Mile Road. You can see from this weekend's activities that I did not win with a fight with a ladder. I have had multiple people ask me to speak on their behalf with regards to the zoning change. I wanted to first discuss what the area is currently. You have a map in front of you. It shows you the urban agricultural in relation to the light industrial and what the condition of this urban agricultural is. The properties are in what I would consider pristine condition. They are residential properties that are very desirable. The people are humble. We don't have huge houses. They're nice houses, but small houses. But overall, all of the properties are well maintained. The farms are utilized and cared for. The yards are maintained. And the neighbors in general know each other and occasionally bicker, but for the most part get along. While there is currently a surplus of properties residential available in Casper, Wyoming, it shows how strong of a community this is currently. If you take a look at the first two maps on the first page of the presentation, the first one is Zillow.com. On the left side, those 4 dots are the only residential properties that are available in this area currently. If you take a look at the map on the right side, we are in a bit of a downturn, and there is becoming a surplus, both in residential and actually light industrial. I looked it up online, and I didn't put it in my presentation, but I would like to address it because the other party addressed it. There's currently, on this REMAX website, 45 commercial properties for sale. That's not including all of the properties that are for lease. And I drove down Robertson Road itself, and there are 3 out of 11 of those commercial properties on that road that are for sale or lease. That's 27% of the commercial properties for lease on the road. If we go ahead and switch to the second page and discuss Mr. McGlay's request for the zoning change from urban agricultural to light industrial, Mr. McGlay's reasoning is that the environment has changed through the period of time. This has already been addressed. The zoning in the area has not changed for the past 35 years. It's easy math. I was born in 1980. I'm 35 years old. That's how long it's been. I would argue with him that there has been a large change in the area, just not in the same fashion. The greatest change in the area is that there has been an increase in residential population, an increase in occupants on properties through subdivision of that urban agricultural property. That should be more of a deterrent as opposed to an enhancement for light industrial to be coming in. Greatest reasoning is if you commingle and you intermix light industrial with residential properties, light industrial just naturally has greater risk factors. It's not through malicious behavior or anything like that. It's just simply that light industrial has higher activity and they have accidents. A means of protecting community residents as well as workers is by separating those two out. And the reason is, your light industrial areas that you have workers go in and work, they're trained oftentimes. They're trained through OSHA and through safety programs. They actually know what the hazards are that they're walking into. They know how to deal with them, and hopefully that helps. But when you commingle residences between light industrial and urban agricultural, you create a greater risk factor where those residences, those families, are not trained for light industrial activity. They don't know how, you can't really tell a 2-year-old he can't run out into the street to try to save a frog that's hopping the way or catch a ball or do any of that manner. You just have to hope that your community as a whole is going to protect your family. And if your community has large trucks that unfortunately are not capable of stopping on a dime, it could be an issue. Another concern that was brought to me by many of the residences in the area is simply that it's going to have a negative impact on the surrounding properties I realize that's not a reason to fold on this, but I wanted to mention it because a lot of people express that concern. They're concerned about the noise level changing. They're concerned about the increase in lighting at night. They're concerned about dust control. Anytime you create a yard for your light industrial, you strip the vegetation, and that creates dust. All of you know, driving through Wyoming, if you drive past a yard, you might want to wear goggles if you have your window rolled down, because odds are you're going to get a little dust in your eye. The biggest thing that I will take your time on is that multiple landowners conveyed to me that they purchased their property believing that there was a covenant and other restrictive warranty deeds that was created on their property that protects them from light industrial encroaching onto this urban agricultural property. I decided to research that. It does sound like Mr. McGlade is aware of this warranty deed, so I'm going to skip the first line. But it basically amounts to anytime you purchase property, you have to do your due diligence and know what you're purchasing. Daniel McGlade's property is subject to a warranty deed restriction. The warranty deed restriction is number 127760. Jay Nichols and Sybil Nichols, I was friends with them. I have to thank them for being smart and creating the warranty deed. The warranty deed is binding to the property. It binds all current and future owners of the lots and parcels involved, unless the persons owning the majority of the acreage within the lands agrees to change the covenant in whole or in part. So there is a stipulation that you have the capability of changing it. It's not set in stone, but you do have to record it when you change it.
Mr. Chairman, where are you reading from the deed here now? Is that what you're reading from?
No, I'm sorry. I'm reading from the presentation I gave you. It's a summary of all three majority acreage owners' signatures that tell you that they oppose the zone changing and change in the warranty deed. They do not want light industrial on the properties that are protected by this warranty deed. And a warranty deed for me was new. I had to research. I had to get a little bit of help with this. What I understand now is that light industrial activity can only occur legally if you have both the zoning and the warranty deed restrictions that permit for that zoning, permit for that light industrial. You can't have one cross out the other. They have to both be in order. What that means is even if you recommend for the zoning to be changed to light industrial, even if they do go ahead with this process at the final commission, there are legal ramifications. A common misperception among lay people is that the deed restriction is not stated or referenced in the current deed.
There was lighting, but that already exists. That was kind of why I was up here. It already exists in the north. There's a drilling company right across the street. There's all types of light industrial activities out there. This is not added to it. It's just adding it, expanding it out. But it already exists in the companies that are already out there. And I won't go into the legal issues with the warranty deed, because that's, if Heather was here, you could ask her. But that's obviously, as stated by Trish, we talked about, that's a civil matter. That doesn't need to be addressed by Any other questions?
I also read in the packet that this is kind of a speculative type venture where the property's been purchased, and he's hoping to get the rezoning, and then he's going to sell the property.
Sell it or lease it.
Sell it or lease it with a higher end use, I guess, if you consider land or light industrial higher end use than urban ag. Is that indeed the case, that, or is there a buyer or a leaser on the line to move in?
There is not at this moment. There's been discussion about it, but we didn't want to enter into any agreement the purpose obviously was to convert it over to leasing for light industrial, but it's never, and it's still not the intent of the applicant to put a house on there to be part of this neighborhood. Second of all, they talked about how this land has been subdivided, and when I met with Trish today, I kind of brought up urban agriculture requires that all the acreage is 10 acres or greater. So I don't see too much more subdivision going on out there because it wouldn't be allowed underneath the current zoning.
With that, I'll close the public hearing, open it up to the commission. Anybody you wish to call, talk to, or you just get off this?
I don't have any further questions.
Okay.
Does Mr. Ladson have any rebuttal at all?
Thank you. Thank you, Mr. Davis.
Real quick, it's usually turned out to come out of attorney's mouth, but really it is going to be real quick. I really do appreciate Ms. Peterson. She did a wonderful job in presenting on behalf of the landowners, and I applaud her. Some of the things just to look at, and I agree that probably is a great neighborhood. Obviously, they all showed up, so they are very neighborly. They got together, come as a concerted effort, and I think that's wonderful. If you look at that acreage,